Good afternoon, everyone. Welcome to Beverly Hills Bar Association CLE presentation on deposition skills. We have three great presenters. I'm going to read you their bios and then we'll get started. First, we have Dan Kramer. Dan Kramer is the founder of Kramer Trial Lawyers, APC in Westwood. He's a trial lawyer who tries cases throughout the state and specializes in catastrophic injury and wrongful death cases, as well as employment. Dan exclusively represents plaintiffs. Last year, he received a $12.6 million verdict for an injured electrician in one of the first post-COVID trials in Stanley Moss. And just 2 weeks ago, he received an $11 million verdict in Santa Monica in an auto versus pedestrian case, where the jury awarded $10 million in non-economic damages. Dan was recently reelected to the executive committee for ABOTA and currently serves as the chair of the Beverly Hills Bar Association PI section, and he's a member of the Beverly Hills Bar Association Board of Governors. Welcome, Dan.
Thanks.
Sure. Next, we have Rachel Kogan. Rachel began her litigation career in New York in 1994, defending hospitals and doctors. She worked as a senior associate at the country's largest professional liability law firm, Wilson, Elser, Moskowitz, Edelman, and Dicker, focusing on defending medical professionals. After practicing for almost 10 years in New York, Rachel relocated to California in 2004 and continued her career at Schmidt and Voiles, defending doctors in all areas of medical negligence. Now, Rachel has worked for the last 14 years at Fraser, Watson, and Crouch. And Rachel was the 2020 and 2021 president of the Southeast District Bar Association of Los Angeles. Welcome, Rachel. And last but not least, Brian Lepak. Brian Lepak has been a member of the California State Bar since 1989 and a certified specialist in family law since 2010. He was a partner at the well-known family law firm Trope and Trope LLP and opened a successful solo practice when that firm dissolved in 2016. Brian has been chair of the Beverly Hills Bar Association Law Practice Management and Technology section for the past 4 years, was co-chair of the BHBA Family Law Section Executive Committee from 2015 to 2016. He served on the BHBA Board of Governors from 2017 to 2021. Brian is also a frequent speaker for Beverly Hills Bar Association, Los Angeles County Bar Association, AAML, and CEB. And in case you don't know, my name is Anthony Ross. I'm president of the Beverly Hills Bar Association. Again, welcome. All right, Kathleen, I'm ready. So the full title is Best Practices for Effective Depositions. Next screen, Kathleen. This lecture has been made available for informational purposes and educational purposes, as well as to give a general understanding of the law, not to provide specific legal advice. Next screen, please. Okay. So just so you know, I will read the slides and also ask questions of our panelists. This is somewhat organic, so they may jump in, when they have information to give to us. First one is on deposition priority. There is no priority of deposition set forth in the Discovery Act based solely on who sent out notice first. The fact that a party is conducting discovery, whether by deposition or another method, shall not operate to delay the discovery of any other party. California Attorney Guidelines of Civility and Professionalism prescribe that when another party notices the deposition for the near future, absent unusual circumstances, an attorney should not schedule another deposition in the same case for an earlier date without opposing counsel's agreement. Before I leave this screen, Brian, you want to kind of tell me what that would be, why this is important?
Well, I guess concerns of a litigation attorney is that you send out notice and the other person tries to take a deposition before the time you were going to take your deposition. So there's always a question as to whether you should just send out your notice without trying to talk to your opposing counsel and set the deposition date and potentially move it later, or do you just reach out to them first to try to agree upon a date and hope that the opposing counsel doesn't get a little squirrely and then decide to send out their notice before yours? So the question is always, should I send notice first or have a conversation first? And I would say that I can't stress enough that there should be civility and cooperation and communication in litigation. I think that we as litigators are trying to take money from one pocket and stick it in another, or trying to make sure that our client's money is staying in their pocket. And that really can cause people to get angry because they don't want their money taken. And they want you to absorb their anger and then use that anger or act in a similar way when you're conducting the litigation. And I think we as attorneys have a duty to our own sanity as well as the clients to not take on their mood and try to litigate according to their mood. And oftentimes we have to communicate with our client and explain to them that you don't have to be aggressive, you don't have to be a not nice person to handle the litigation, and explain the process to them. And I think in communicating with the client, that's helpful. I generally, to go directly into the whether I send out notice first, I guess it depends on my opposing counsel and it depends on the client. Sometimes you have that client that's still insisting that you have to act in a more aggressive way. And in that sense, I would send out the notice first if that's what the client wants. Usually I'll explain the process to the client and give them a choice, especially if it's a controlling client. Oftentimes, if it's a mousy client, they'll let me make that decision. And if I have a good relationship with opposing counsel, that I can trust that they're not going to try to undercut me, if I'm cooperative with them, I may reach out to them, because it's always nice to cooperate and set that mood for the litigation. It comes back when it comes down to the trial and you're trying to coordinate your witnesses at trial, or you're trying to get your exhibits in that maybe you need some cooperation in. So it's always good to set that tone even early on through the discovery process that you're cooperating and you're communicating. If I don't trust my opposing counsel, probably I'll send out the notice and do a cover letter that will say, hey, I'm open to moving the date. And that's probably, if I would had to be a guessing person, I'd say more often than not, I'm just sending out the notice and with the cover letter saying, hey, I'm willing to move the date, especially if I'm not trusting of the other side. I would say if you're an associate, definitely reach out to your partner and ask what that partner wants you to do. And because they may have a relationship with the opposing counsel or a relationship that requires some cooperation, and do what your partner tells you to do. But that would be what I would say as sending out notice of your deposition.
Thank you.
Right.
Kathleen, I'm sorry, I was just about to, Kathleen, next slide, but I was just about to say, would anyone else, Dan or Rachel, like to jump in on that?
So I'm very anti-unilaterally noticing depositions. I don't bill by the hour, maybe that's why. But as a plaintiff's lawyer,
let me just interrupt and explain to everyone that Dan is a plaintiff's attorney, so he's speaking from that perspective. Go ahead.
Yes, that's correct, Tony. So, I think it's a big waste of time. I mean, I get it. And sometimes we have to, if we're running against the deadline, the cutoff or expert cutoff for whatever reason. And sometimes you have an attorney that does it. But when I get unilaterally noticed depos, I am going to object, and then it's going to be a bunch of paper wars. And I know if I do it, same thing, the clients or deponents never available. To me, it's just a huge waste of paper and time. So I tell my entire team, send an email, give a list of witnesses you want to depose, some timeframes you're available, try to work with them. Big believer in civility. Brian's 100% right. I know Tony and Rachel are big believers in civility as well on all sides and all different areas of the law. But to me, it's a big waste of time. And so we try to coordinate. With that said, if I give them like a week or a week and a half maybe to get dates, I think by then you should be able to get dates of those deponents. At that point, if not, I'll say, look, like we're going to have to unilaterally notice these. I hate doing that. Please just give us dates. If they still don't cooperate, you have to. But I'm just personally, I just don't like doing it because I know it's just going to be a huge waste of objecting and paper back and forth. But Rachel, you may have a different take.
Well, I mean, as far as the billing goes, the point due to bill for to get priority isn't going to make a big deal. But I agree completely. Of course, you should be civil and try and coordinate with the opposing side. But I tend to try and send out my initial discovery and depo notice and introduction letter when I serve a responsive pleading, just to kind of cover the bases and get the ball rolling. And of course, we're always willing to change deposition dates to coordinate everybody's schedule. I mean, that's just basic.
Thank you. Next slide, Kathleen. Okay, location of deponent. I don't know that it makes sense for me to read the entire slide because it's a lot there. So if people can read the slides and we'll move on to the questions. And so this is about the location of the deponent. There is a limit to how far a deponent is required by the code to travel in order to attend a deposition. Anyone have anything they want to say about this slide before I move on?
I guess I can kick this one off. So I haven't done an in-person depo, I don't think, since COVID. I don't know if you guys have, but I definitely haven't.
Nope.
It's all like this. I don't really plan on doing an in-person depo again. I don't know. Maybe I will, but I love it. I love the Zoom depots. It makes it so easy for deponents. Everyone saves on travel cost and all that. One concern, which we talked about, in our prep sessions is, how do you protect a client or deponent from reading answers, their attorney messaging them? That's always a huge concern. I was extremely concerned about that the first time I took a defendant's depo. So, I start off every deposition on the record asking, where are you located? Who's in the room? How many screens are in front of you? Tell me exactly all of the applications in front of you. Where is your phone located? And I frequently ask them that. Because I want to see where they're looking, and then they automatically always going to look when they're saying what screens and who's in here. They're going to look to that place, so I know whenever they're looking there, I know they're looking at something. So, but just to kind of a different aside is that I video every single depo. In my opinion, I don't know if the defense agrees, but on the plaintiff side, if I'm always looking to trial, and every case that we're litigating, I'm thinking this is going to be in trial, and so if a depo is worth taking, it's worth videoing. Because you want to use it at trial. So if you think the defendant or the deponent, both sides, whatever, or expert is up to some, no good on their screen, the jury will see, that they're looking around, or, that I think they can pick that stuff up. So I think you always got to ask all of those detailed questions, get them to confirm under oath who all is in there, and keep asking them. I see them look down. I'm saying, like, what did you just look at? What did you just read? What are you looking at right now? Unfortunately, it's the reality of it. I don't mean to be accusatory, but sometimes you just got to do it on the record. I don't think there's really any other way to do it. I also will insist, if the deponent's attorney is also in the room, that they have their screen on as well, because I've seen it where their screens are off and I don't know what they're doing, and if they're like mouthing and doing whatever to the deponent, especially if they're in the room, I'll stop the depo if they're going to do that, make sure their screen's on so I can see everything going on. I wouldn't allow that to continue. I don't know, Rachel and Brian, what do you guys think?
I had a deposition yesterday where the deponent said that their computer that they were in front of their monitor didn't have a sound. All they had is a picture, so they had to have their phone out for the sound. So there were two pictures of the deponent. So I said, please, when you're answering the question, look at the phone. I don't want you looking at your computer screen reading answers that are being emailed to you by your attorney. So that's how we had to handle that particular circumstance. Sometimes you might ask the deponent to sit further back so you can see, or to adjust the camera so you can see not only their face, but in front of them, to see if there's anything being slid in front of them as well. So that's another way of handling it.
I would agree that, the Zoom deposition is really kind of opens a can of worms for the people who are going to cheat. And, I've heard stories about witnesses who've got a whiteboard in front of them and some, unethical attorney writing the answers. So if you suspect something like that is going on, and you could see the witnesses looking off to the side for answers, you got to stop and figure out what's going on. I mean, because the testimony then just is tainted.
Well, but again, and I think this goes back to why the video is so important, that you're going to show it to the jury, is that you can call that out on the record, and then, a judge may let you play that to the jury. So the jury is seeing all this shenanigans going on.
Absolutely.
I have to say, I've not had it happen to me yet. It is something I'm aware of, but it's not happened to me yet. So I sometimes will ask that they pan the camera around the room so I can see who's there or who's not. But other than that, I really haven't had it be an issue yet. I hope I didn't just jinx myself.
No, Tony, there's a good question here. I think that comes up a lot, that I'm seeing a lot.
Okay.
That Sarah Broomer asked about this code section in subsection B that says the attorney may be physically present. Is that correct? So what I'm seeing a lot is there are battles where from our side, the defense attorney is insisting upon an in-person depo, and then it sort of becomes a fight. And I honestly think the court's figuring it out, whether, you know, you can force someone to be in person. I think my impression of different judges are obviously ruling differently, but we're in a new world. And I think judges are going to require the party insisting upon in person to have really good cause to do so, such as, you know, as someone else asked the question, they don't believe that, they believe there's nefarious conduct at hand, and they think, you know, it's really important. But I think it's going to be a standard that's going to be pretty tough to meet. You know, you have to prove it, like it's really that necessary to be in person, because I think judges are inclined to just let this continue on because of it saves everyone time and money. Are you guys running into that at all?
Oh, yeah, I agree with you, Dan. We're running across that quite a bit where, you know, even certain plaintiffs' attorneys, they want to take my doctor's deposition in person, and the code really isn't so clear on whether you can force a deponent, you know, to appear in person or not. And like you said, I think the courts are going to lean towards, you better have a good reason why you're going to force somebody to appear in person, especially for a doctor who has to take time out from treating patients to travel. It can take, you know, hours to get to where they're going. And so I think most people are really in favor of Zoom depositions. It's worked out really well.
Go ahead, Brian.
I actually noticed up a live deposition for next week, and instantly opposing counsel said that ain't going to do it, and instantly decided it was going Zoom. It's not worth the battle. I agree. It's not worth the battle. There are other issues to be concerned about. There are people who have compromised immune systems. And so forcing someone or trying to force someone into an in-person depo probably not going to be taken well by the court as well as by opposing counsel. Next slide, please. Okay. This is what we were talking about before, about when you notice depositions, whether you would do so with consult or not. And so I think the code does provide now that we can actually serve by email. Is that what everyone's understanding is? We can now serve notices as well as everything. Now I think the way it works actually is that all participants in a particular matter who have responded via email, I think automatically you are then subject to email service. Is that how people understand it? I would say in every one of my cases, I immediately reach out to opposing counsel and try to get with them an agreement for electronic service of all documents. It's just so much easier, saves on the cost of putting stuff in the post office. And I have yet to have somebody say, I don't agree. Everybody immediately says, great, we'll do electronic service. And so we end up serving everything electronically.
Right, and I guess what I'm pointing out now, Brian, is in the code section is here. It's now been codified that way. So that you're right, because we used to always have to get people's permission to use electronic service. I think the federal courts didn't. The federal courts actually did it the way this is now done. You're authorized to serve electronically, particularly when someone has provided their email address either in their first form of service or in some other manner. But I think we are now authorized to serve electronically now based on COVID. It's been codified. In
our electronic service agreement, then we add things like it doesn't add any days onto the service, and that we have a cutoff on when you can serve it in that particular day. So like 6 o'clock still constitutes being served that day. So we add in little tips for that.
That's a great idea, Brian.
It is.
You don't get served with, say, an expert designation at 11:59 p.m. on the day it's due.
That's a good point. I have not had that happen.
Having a cutoff time is a great idea.
Yeah, it is. Dan, anything on this issue?
No, I agree. I think it's codified.
Yeah, but I've never thought to even make it more clear about when when the cutoff is, because you're right. I work weird hours, so I would serve. I don't necessarily serve an expert designation late at night, but I could see someone doing. Okay, next slide, please. Okay. Objection to deposition notice.
Sorry, I'm sorry, Tony. I just one quick thing on the depo notice. Make sure you have the language in there that you intend, if you're going to video it, that you intend to use it at trial. Because if you don't, then you potentially waive your ability to play the video at trial. In the trial we just had, we played we didn't call one treating or expert doctor live. It was all depo video. If we didn't put that proper notice in there, then we could waive our ability to do that. So make sure you have that language in all of your notices if you're going to video.
That's important. Thank you, Dan. And what I do is mine all say we reserve the right to play the video in lieu of the person live, because you don't always, now with COVID, probably we're going to do it more often than not. But it's good to make sure it's in there, because you're right, you could waive the ability to do that. This is on objecting to deposition notice. I'm just going to look at the questions really quick to see if there's anything on objections. I mean, this one is straightforward. You have 3 days prior to the actual deposition. You have to serve your notice, at least by mail, for if you want to object to the deposition. I object to every deposition. I mean, kind of the way I preserve my objections for everything else. I've had opposing counsel get upset and think that I was actually not producing the witness because I wrote my objections out. Do you guys do that, or have anything to say about the objections to deposition notices?
Yeah, or go ahead, Rachel, go ahead.
Oh, I was just going to say, I mean, I typically send out objections to deposition notices also. I mean, I usually add 2 days kind of for electronic service. So I have it calendared for 5 days before, but especially if there's a demand for production of documents that I'm not going to be able to produce, I put that in there. If it's unilaterally set, I put that in there, especially if it's in person. That would be a #1 reason to object, but for any one of those reasons, I almost always object.
Yeah, I think the biggest, where it actually matters, I mean, yes, you get boilerplate objections, but where it actually matters, like Rachel said, is RPDs, request for production, that is attached, because you got to treat that the same as discovery RPD without a depo. But also in the person PMQ or PMK depo notices, usually the defense, we send out a long list of the categories of who the person most knowledgeable of a corporation or an entity is. And then the defense would need to object to either the categories are too vague, or they don't have someone for that, or there's multiple people under each category. So that's where, as a plaintiff's lawyer, I'm paying attention to their response to their objections, is those 2 areas. And I think as a defense attorney, you need to object to a lot of those categories. I know Tony and Rachel, you guys probably get PMK depo notices a lot. I mean, I think that's a big factor.
Thank you. True, very true. I think we can go to the next slide. Okay, quashing a deposition subpoena. I'm going to bypass the language and throw this out to the 3 of you. Let's go with Rachel first. Quashing a deposition subpoena. Have you done it recently? On what grounds do you normally do it?
Not really. I mean, I think the last deposition subpoena I may have quashed, trying to think, maybe it was an ex-Apex employee of a hospital that is no longer working at the hospital, and they wanted, the ex-CEO's deposition instead of going right to the source and wanting the doctor. And then I would quash that type of deposition subpoena as being, not the person with the most knowledge of the incident, but very infrequently. Usually we can meet and confer and figure it out with opposing counsel. It's very rare that I would need to do that.
So because I do experience this sometimes, if we get wind that there is sub rosa, meaning surveillance of the plaintiff, and that's in the discovery responses, and they have to list the name, I'll automatically subpoena that person to a depo. And so we get a lot of motions to quash on that. I think a practice pointer, again, I don't know why I'm giving advice to defense attorneys, but I think objecting alone, a lot of times people are mistaken that an objection alone will carry the day and that'll stop the depo from happening, because it does when you're dealing with a party notice. That won't fly with a subpoena. Subpoena is a court order to appear. Just simply objecting to it and then sending the objection to opposing party and the deponent does not alleviate their requirement to appear under subpoena. So you have to go to that further step of actually filing a motion to quash, or else the subpoena is certainly enforceable. And I've done that where I do a motion to enforce the subpoena when they don't show up, and the court's going to grant it if there hasn't been a motion to quash.
I've been on the other side of that, Dan, just so you know. I mean,
Okay.
I got a new investigator now, so they're not caught quite as easily, but
Oh, we'll find them. We'll find them. Don't worry.
I'm sure you will. But, I agree, when we get the subpoena to take the deposition of that investigator who's taken the sub rosa, I have moved to quash that deposition. And of course, it's the defense's position that anything related to that sub rosa is work product. So we've got to go in and quash the subpoena. I'm sure you would think differently, of
I
course.
think I disagree just a little bit on that, but we'll let the judge decide.
And just because Dan gave a little bit of advice to his opposing party, I'll say the same thing. I wait on sub rosa until long after I've answered those questions at deposition.
We know those tricks, Tony. Don't worry. We know those tricks.
Brian, did you have anything else you wanted to add?
Well, where it may come up for us is if somebody's going to keep trying to take somebody's deposition repeatedly and even beyond the 7 hours that they might be entitled to, that on the grounds that some new issue came up or something was unexpected and having to deal with it. But usually people in my field tend to cooperate, and so it's not common.
Got it. Okay, next slide, please. Protective order. Okay, so this is kind of in keeping with the motion to quash the deposition. Protective order, well, you can use protective order for all types of discovery. I guess I'll ask, Dan first, this is plaintiff's counsel. Have you had to use a protective order, or is it more likely, it seems to me, be more likely that you'd be the recipient of the protective order, yes?
Well, I mean, I think both sides probably use it fairly equally. I mean, if anything, so basically the protective order, I mean, as it says, is if, you want to stop a deposition because it's getting too far afield, or say that they're starting to get into very private areas that are unrelated to the injuries, at least in the PI world, psychological issues that are not relevant. And the attorney does not just accept that, hey, move on. You can stop the deposition and seek a protective order. That's really the mechanism of how it would work. They're very rare, frankly. I mean, talking about, I don't think I've ever done one. I mean, I can't think of ever having to do one. I can't think of, I think maybe one time someone tried to do one against me, but extremely rare. It has to be pretty egregious conduct, I think, by the opposing party to actually force them to do this. I don't know, Brian and Rachel, do you guys do these or experience them?
No, very rare.
No, I mean, we've used the court form stipulated protective order for discovery issues that are sensitive. And this is where the civility with your opposing counsel really comes in, that if there's sensitive issues that are going to come up in discovery, regarding a minor or privacy issues, then I think it's totally appropriate to use the stipulated discovery protective order to make sure that that information doesn't get disseminated beyond the boundaries of the litigation.
Yes, and I should, with the caveat, I was thinking more of a protective order for what's going on in the depot, but 100%, when we sue big box stores, for example, we're getting a lot of protective orders just at the very beginning of the case for discovery. I mean, we find them sometimes, unless it's truly reasonable, trade secret stuff, makes sense, the court's going to grant it. But yeah, in that context, I see them a lot. Depositions, I don't see them hardly ever.
Yeah,
I would say what's common is you threaten to walk out because you're asking inappropriate questions. The person will move on to a different subject and potentially come back to it at the end of the deposition, but try to complete all but that of the deposition. And then there's an issue about litigating it later. Usually I don't see depositions being ended. It usually is that somebody will move on or change their behavior if they're being abusive in their questions or disrespectful. They might change their tone, and usually you can take a break and bring the opposing counsel out in the hall and have a conversation about why is this happening and try to calm the situation down, and before a protective order would be needed.
And just for both sides, I mean, judges don't like these. They don't like when we squabble and we just like fight with each other over stupid stuff. So it doesn't matter for one side or the other. Just take a break and just work it out, because the judge's going to get pissed at one side, probably both of you, and it's just not going to set a good tone with the judge for the case.
I agree. There's a question in the chat by M. Linda Sheridan, which says, what authority do we have to stop the deposition if we believe there's coaching going on? And so it's appropriate here. I wasn't going to talk about the coaching, but in terms of stopping the deposition, I mean, the code does, and I don't remember the section, the code does give us an option to stop a deposition and seek judicial intervention should we need it. Again, rare, those are rare, as Dan just said, the courts do not like these, but we can do it. But it's a risk. You have to have a very good reason to do it. If someone's really pressing on an issue that is, that is privileged, that's a pretty clear cut place to do it. But for the most part, I think you're right. Meet and confer, take a break, go into the hallway, talk with opposing counsel is a much better way than trying to stop a deposition or even a protective order for a deposition at least.
But Linda's a great friend of mine. Hey, Linda. I think on the coaching thing, if I assume you're seeing it over Zoom. I think in that situation, you make your record and you almost say exactly what is going on as it's happening, so that then you can show the judge, like, look, Your Honor, this is just going on, and I know what's going on. I just need to insist on it in person. That's what I would do in that situation.
That makes sense. Next slide, please. Okay, the deposition prep outline. So, there was a bunch of questions that are not here, so I'm going from memory, guys. So my apologies on not having the specific questions at hand. But in terms of deposition prep outline, I'll ask Rachel first. Rachel, do you have a standard way of doing this, or is yours targeted to an individual deponent?
It has to be targeted at who the deponent is and what the case is about, and what you need out of that deposition. If I'm taking a plaintiff's deposition, I need to figure out, what are the issues that are going to help me defend the case, and also know the medicine, make a detailed outline referring to the medical records. What exhibits am I going to be using? Make sure those exhibits are bait stamped, and that everybody's working off the same set of records. I'm always going into every deposition thinking, how am I getting my client out of this case? So what can I get out of this deposition that's going to help me defend this case? And obviously the plaintiffs coming from the other side, they want to get their story out. They want to but it's the same, really. I need to get the story out so I know what I'm defending, and I need to make an outline just so that I can cover everything. And I don't follow it step by step during the deposition. I like, you have to listen to what the deponent is saying, but and take it where it goes. But the outline is really important, just so you can keep bringing yourself back to what is it I need to cover. For me, it's always standard of care, causation and damages, liens, any other issues that I need to address.
So so this is a very big question that we could probably do a whole webinar on, but so from my perspective, it 100% the last thing Rachel says, don't be married to your outline. You see so many newer attorneys who read it, the deponent will give just some amazing answer that then leads you down a different rabbit hole that can completely flip the case, but they go to their next question. It's like, oh, sometimes I sit there, I'm like, wow, thank God we dodged a bullet there. They're reading their outline. This is amazing. But in terms of outlines, so I think timelines are important. Doesn't matter really what kind of case, but for an employment case, for example, where it's very email heavy, what I do is I do a whole the story of the case, each email in chronological order. I then bold and underline it. I then have the exhibit I want to use, the exhibit and exhibit number I want to use during the depo. And then my notes below it, what I want to talk about, a quick summary of that email, what I want to talk about. And it helps me, keep my chronology in order as I'm going through. And then I use that for the other witnesses. That's an employment case where it's very, fact intensive and document intensive. But Rachel's 100% right. You want to, in your depos, you do want to make sure you have the language the way it needs to be said with an expert, within a reasonable degree of medical probability, X, Y, and Z happen. Or do you think this fell below the standard of care for safe hotels? Like if you're asking a PMK, you want to make sure you got that locked in Casey language. So have the elements. I mean, it goes back to law school, but look up the Casey, which is the jury instructions that the judge is going to read the jury. Go to those first, find out what is the elements I have to prove. Just like Rachel said, have those listed out, and then go through the witnesses about each of those elements, and then you lock them in, and then you have nice sound bites for trial. But again, for video depos, you want to make sure you're getting that sound bite, and it could take 5 pages in a transcript to get that one sound bite because you're getting objections. The witness is going off on tangents, giving long-winded answers. Just keep fighting through it. You're going to get a lot of asked and answered, but fight through it so you get the exact wording that you wanted when you developed your outline that matches the law. So, I mean, I think it's important to have an outline, especially if it's a high fact intensive case, but don't be married to it.
So one of the lessons I learned as a young attorney was when I sat with a partner who was taking a deposition. And what he liked to do was he liked to jump around at times. He knew his outline, but he liked to jump around because he liked to have the witness not in a flow necessarily sometimes. And he could jump from question to subject, trying to keep the witness on their toes. But what he'd like to do was at one point in time, he'd say, let me summarize what I think you've told me so far. And then he will ask those questions now in the order that he wants to, because he knows that was the bite that he was going to use after. And then it's really repeating the questions, which is probably not right. But that was the tactic to have that. Here's my 2 minutes that I'm going to be using after all of those other questions that I had asked. But it was having an outline, but not necessarily following it and using it for a tactical advantage.
Objection misstates the witness's testimony, Brian.
Right. Which is exactly what I would do as well. But I can see that practice would help. And I agree with you, Dan. I will ask the same question. I will sometimes warn people. I will ask the same question 12 times until I get the answer that I need to move on. If there's a lot of hedging by the witness, I will ask it again and again and again, because the worst thing is to have, gotten the correct answer, but you can't point to it in the transcript. And then you're really kind of, you really wasted, the deposition if you can't really get a clean answer to your questions.
And that's why it's important it takes a while. I mean, you're not only trying to lock people in for trial, but you're trying to find information, and it takes a while to get that information. But once you do, synthesize it in one question to get that yes or no answer to really lock them in. Don't give up. I've read too many of my own transcripts where I'm like, God, I can't believe I forgot to lock them in on exact. I thought I did, and everything seems so clear, but you read the transcript, you're like, man, they now have wiggle room at trial, and you never want to give them an out at trial when they're on the witness stand.
And there are some witnesses who are really good at keeping that little wiggle room. So yeah, you have to be careful. Yeah. I just want to say, because I don't know, I see there several levels of attorneys with experience and non-experience, and we mentioned PMK. That's person most knowledgeable. In case people were wondering what that stood for. Next slide, please. Okay, so now we're preparing a witness. Here's a list of what we thought would be important so that everyone would have some sort of a guideline in terms of how you prepare a witness. But Brian, what is your general, overall practice in terms of preparing a witness for deposition?
I definitely bring the client in and go over all of those points. I have a cheat sheet of things that I have to go over them with, and try to explain the process to them. But one of the things I'm trying to make the witness do is feel comfortable about the process, because so many clients have never had a deposition taken before, don't even know what a deposition is. And I have to explain to them why, in part because I want them to feel comfortable in the process. So by telling them all of these things, I will even ask them the admonition, your standard questions that get asked at the beginning, to see what their answers are going to be, so that when their deposition is taken and all those same questions are being asked of them, they feel comfortable because they go, oh, I knew this was going to happen, and they have an answer. And that gives them that confidence at the start of the deposition that, oh, maybe this isn't going to be so easy, and my attorney's smart because he knew those questions were going to be asked, which helps to build my credibility with the witness as well. So I just try to get them to understand that the process, and again, communication is a key. Trying to give as much information as you can to the client, but understanding they're probably not going to remember everything, but giving them that comfort by giving some familiarity before the deposition actually happens. I try to stress to them about honesty. You really do, because if they start to think, what's the creative answer I need to give? You're already getting them in the wrong position of thinking they have to come up with set answers. Be honest. If you can get your honest answers out, you're going to be fine. Come across with honesty. That's important. I would say sometimes where there's some difficulties is clients have a set answer they want to give and they're stuck in a position that you think may not be helpful to your case. That can be difficult because you have to talk it out with your client and discuss why that may be better said in a different way than the way they're trying to say it for the sake of their case. Difficulty comes when they're set that that's the answer they want to give, and you know how damaging that's going to be. And that's why you have these things called emails to say, here's what I think, and I'm concerned about this, and cover your butt with the fact that you've communicated that point with them. I would say sometimes with clients, I have difficulties that they want to bring a third party to the deposition. They need their hand held by their mommy or by their best friend at a deposition, and trying to talk them off of, you're going to be fine. Sometimes there's that difficulty. And in fact, they want to bring that same person to the depo preparation, and understanding that, no, so there's this thing called attorney-client privilege, and having this person sit there may or may not be in your best interest, depending on what information they can provide, but I wouldn't recommend it. And usually I don't permit that to happen, but that's a difficulty that can happen in you're preparing your deposition. Letting the client know that they're going to get asked, what did you look at in preparation for this deposition? And having them not say, oh, I looked at all the communication between you and between my attorney and myself. Because that document then could potentially be produced. Or who did you speak with in preparation of your deposition is going to get asked. And that could potentially lead to problems, because the second Dan hears who that other person was is the second they get subpoenaed. So those are things that I think are difficulties that I deal with the client in preparation.
Yeah, just to add on to the tell the truth is obviously the most important. I think if you're representing plaintiffs, and you got to explain them why it's so important to not exaggerate or change or alter any way whatsoever. It's because, for example, if you have a client who's injured, but they go to the gym and they try to go to the gym to feel better or make themselves stronger, they think going to the gym is going to kill their case because it's a personal injury case. Like, going to the gym is going to kill it, but lying about going to the gym is a case killer. Going to the gym we can deal with. That's the truth. It's what you're doing. But saying you didn't go and then they have film of it, that kills your case. That's catastrophic to your case. So it's just, I can't stress enough. If you're representing plaintiffs, be 100% truthful. And this requires you going back through, we always get, right when we sign up a case, 10 years of their medical history. It doesn't matter if it's somewhat related to the body part or not. We get it to make sure that we are reminding them of the time they complained about their back 5 years ago. Because in their depo, they either are going to forget or kind of try to hedge and say, no, I didn't have back problems before. But we got to have all the records, assuming the defense has absolutely everything. So it's important. Your job as the attorney is to have absolutely everything possible. Don't just take your client's word for it. Remind them of it so that in the depo they are accurate. It's also making sure you don't speak in absolutes if you represent a plaintiff. It's just, I can't run. It's like, well, you say it's hard for me to run. It's just, it's not speaking in absolutes, because again, that they could have sub rosa, that's direct impeachment. So it's making sure that you're answering truthfully, but keeping it broad, I think.
Never and always are difficult words to hear in a deposition.
Yeah.
I would just add to prepare your witnesses on either side to check their social media, because the first thing we do as defense attorneys, and I don't want to give away too many secrets, but we always check a plaintiff's social media account, and I can't tell you how many times somebody said, well, I'm unable to work, or I'm blind, and next thing you know, we've got them driving their car to go pick up groceries.
But
what plaintiff's lawyer is taking on that case? Jesus.
However, talk about spoliation of evidence, because if you knew that would potentially be something as evidence and your client destroyed it, you could have a lot of problem, not only as the client, but as the attorney, who's going to be told, my attorney said to go destroy the information on my social media.
I'm not saying to destroy it. I'm just saying to be consistent with, we have no money, we're on Medi-Cal, but we just got back from Hawaii, according to my Facebook page. I mean, I would just be careful about what's put out there on social media.
I think that's good advice. Yeah, I will say that I say to my clients, this is not necessarily the time to tell your story. People sometimes conflate deposition. It feels that to a layperson like this might be like trial. Like I should tell it everything. Not necessarily. And so I try to let my clients know, if I'm asking you a question, you have a little more latitude. But if the question is coming from opposing counsel, answer only what is asked, and that's it. And your answer should be short. But that's just from the defense perspective. I don't know how plaintiffs do it. Okay. Next slide, please. Okay, so objections during deposition. Now this is where a lot of the fireworks are at depositions. And so we were talking, as we prepared for this, we were having a kind of a roundtable discussion about how you object if it's not your deposition, meaning you didn't notice it. And so you're there maybe defending the deposition, how you object. And then the opposite side of that question is, if it is your deposition, how do you handle opposing counsel's objections? So I'm just going to leave it like that, and then let each of you chime in on that.
I guess I can. So don't make a relevance objection ever at depo. Again, I every time I see that, I'm like, oh, this person doesn't know what they're doing. So like Tony's talking about, there's certain objections that are waived, and it's to the form of the question, because you need to give the questioner the ability to cure if the form of the question is wrong. So that's one you do waive. The hearsay you don't waive. You can still claim that at trial. Relevance, basically every other type of question you can still bring up later on, but just not to the form of the question. But in terms of if I'm defending a depo, you're obviously supposed to not make speaking objections. And when we say a speaking objection, it's, objection vague and ambiguous. Counsel, I don't really understand what you mean when you say, was the crash, did the crash cause her back injury? I don't know. She probably doesn't know, because she had a back injury, 5 years ago, and that she's going to talk about later, and she's going to be very honest about it. Like, what I'm doing there is I'm speaking, I'm also tipping to my client, what's going on. And, both sides do it. I think it's fair game. Your job is to shut it down and tell them not to coach, but you're not supposed to do speaking objections. So you're not, a judge will shut that down if you do it too much. And this is where you could do a protective order and possibly have a discovery referee come in if it's getting really bad. But, in terms of strictly what you're by the book, it's just objecting to the form of the question is what you were supposed to do. Brian and Rachel, I know you guys are by the book people,
Well,
so I'm sure you do it exactly that way.
I would just chime in. The other, big objections are obviously anything that invades your client's right to privacy. If I'm defending a deposition, I'll instruct my doctor or my client not to answer. If a plaintiff's attorney asks the doctor, well, how much money are you making? It's none of your business. That's covered under constitutional right to privacy, and I would direct them not to answer those types of questions. But as far as to the form, I think the big one is if it's abusive or harassing. But there's other objections that I would make, work product objections or attorney-client privilege objections. Those are kind of the big ones.
Yeah, and you're going to waive that if you don't make that objection, so it's mandatory. No, for those I would instruct the witness not to answer for sure.
Exactly.
Well, so
I would say that everybody here has made a speaking objection at some point in time. It just happens. You do it, and listen. To me, it depends. Sometimes I don't hate objections necessarily because it could be educational.
Right.
You have to listen to what your opponent is telling you. Sometimes they're helping you by making that objection and say, oh, maybe I should ask that question a little better. Let me think about that question. Maybe I'm going to rephrase it so it's not objectionable, so it will be good. So it's not a bad thing. It could be a learning lesson by hearing it. Don't be offended by it. Just like you're asking your client to relax when they're giving their answers, you as an attorney have to relax. Don't let it affect you just because everybody's asking that your opposing counsel is making those objections. It's okay.
And I've been I've been in depositions where newer attorneys take the objection as an indication that they have to rephrase the question or they have to change. You don't have to. You can just let it stand as it is. The attorney was preserving it for whatever reason and just move forward. So really, you do need to listen, as Brian is saying, because you may actually be getting help, inadvertently necessarily, but you might be getting help by rephrasing it. But you don't always have to change the question just based on an objection.
Well, and then So when you like vague and ambiguous is the one of the most common you're going to get. And I always ask, Mr. Smith, do you understand what I'm saying? Do you understand what the word, is? Do you know what that means?
If you ask me-
And
Or
wouldn't
what's
know.
your understanding of that word that your attorney just said was
Exactly.
vague? What do you think?
Right.
And then, okay, using that definition.
Exactly.
blah, 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 is
Right,
a
that's
is a very common way of dealing with that. And sometimes you even may be risky to say to the opposing counsel, what part of that sentence was ambiguous? Because then you might be inviting a conversation.
Right.
Because again, it depends on your relationship with that opposing counsel, how much you trust them to be professional or not be professional. I would say if somebody starts to do a speaking objection, first time around, I'll probably say, please don't do a speaking objection. That's not appropriate, and let it go. I don't make a big deal out of it. I'll say it. I won't make a big deal about it because I don't want to embarrass or start to embarrass my opposing counsel or start a fight with the opposing counsel. It's not helpful to moving the flow forward, and it's just going to affect me. I'd rather focus on the questions I need to ask. If it happens again, well, then I might warn them that if it happens again, we're going to have to potentially stop the deposition. And if we have to stop the deposition, we're going to have to go seek fees from your client, or we're going to have to get a discovery referee. And if that happens, we're going to have to make your client pay for it. And that might stop it. If it continues to happen, as I had said before, maybe I'll pull opposing counsel out in the hall and have a discussion and see if that handles it.
And but I do want to touch on the instruction not to answer, which has come up. Michael Sahigian brings up here. I see it way overused. There's a case law on it, Stewart versus Colonial Western, which Judge Marianne Murphy, I think, wrote or was the trial judge in that case. It's really kind of pretty narrow where you can instruct a witness not to answer. It's attorney-client privilege, or privacy is really it. But people use it all the time if they, ask and answer it. I've gotten, like Tony does, really trying to drill down, and they're like, well, you've asked and answered. I'm going to do it allow them one more time, and then I'm going to instruct them not to answer. I file motions on that. I file motions all the time when attorneys don't let their witness answer, and I force them to come back and answer the question because I think it's way overused, instruction not to answer.
I would err on the side of caution with that, though, and I do tell my clients not to answer if I think that there's an appropriate privilege, like I said, a privacy issue, or in medical malpractice cases, we get into evidence code 1157 issues with peer review meetings. I will direct my client not to answer those, and books have been written on 1157, and we can argue back and forth about what exactly can and can't be asked about. But I think in certain situations, it's better, at least on the defense side, to protect your client because, I mean, honestly, Dan, 9 times out of 10, we don't get the aggressive plaintiff's attorneys like you do, and maybe they'll just let it go. And this way, the client's been protected.
No, I agree. I agree with that. I think 99% or 95% don't file the motions. They're all bark, no bite.
True,
I find
very
that
true.
sometimes after the break, after that confrontation that might be a little bit heated, the answer sometimes slips in somehow by the witness so that it diffuses the situation, but it slips in the way that they want it now to be answered.
So can I just comment on how this all plays out at trial real quick?
Sure.
Because, a lot of times this is all in the abstract. It's like, well, what are we even doing this for? And so at trial, what we do a lot of times is, like I said, we play video depos. So we designate the record that we want to play at trial. We play an opening statement. We play in our case in chief. We play during witnesses. And then we designate those pages. And then the defense will object and to those passages with whatever valid objection they have, the judge will rule. So it's kind of the columns that we put together for the judge. And sometimes we say that the defense then brings up objection to the form of the question, and our response is that it was waived, and the judge should correctly rule that it was waived. So that's how it is important to preserve your right at trial because that's how it plays out. And then now I can, use that question to impeach the witness where I may not be able to if you had properly objected, or I can play the video passage at trial now because you waived it. Whereas if you had, held your objection at the depot, I wouldn't be able to. So that's how it plays out at trial. That's why we do all this stuff.
Right. A good point. All right. Next slide, please.
Oh, there you go. There's our cheat sheet that I was looking. I was like, oh, what are they? What are they? I have to know it. I can't remember them all.
So I will say here, because I was thinking about this before, and I mentioned this when we were all talking about it. I'm not sure if it's on this list. The one thing to keep in mind, because people forget that another reason that you are allowed to instruct your client not to answer is if the question is harassing or abusive. And so on those grounds, you could instruct your client not to answer a deposition question. Again, that's a very narrow category of times that you can actually, with support in the code, ask your client not to answer a question and not have to worry about the judge overruling you. But if your client is, if the question is harassing or abusive, that is grounds for your telling your client not to answer the question.
And sometimes your client just wants to see you going off to try to protect them at the deposition or to protect that witness. Even if you really, it's meaningless. Sometimes you have to show that force, and hopefully you have an opposing counsel who understands and they know the game and say, yeah, okay, no worries, I got you. And it's part of how the cases play out by somebody just getting into that confrontation, each side pretending that they're fighting for the best for their clients, and then you go on and start answering questions.
I will say the one thing I often say is that television and movies do us a disservice, I mean trial lawyers, because I don't think they ever show depositions, and depositions are key part of preparing for trial, and most times most people don't know what a deposition is. I mean I have family and friends, if I tell them I have a deposition, they have no idea what that even means. So all right, now next slide please. Oh, contentions. I always thought this was an interesting area of deposition. So technically, it's improper to ask the party, a deponent, to state their legal contentions in the case. The problem is that there are a lot of things are contentions, and people forget that it's legal contentions that are not permissible in a deposition to ask of a lay witness. I've had people, opposing counsel, object because I've asked about, a person's contentions about how they feel or what they think happened in a certain place. And so it is a specific type of question, a legal contention. It's not just anytime you ask a deponent their contentions about anything in particular. Anybody have anything they want to say on here, or we can move on?
Well, I mean, go ahead, Brian.
In my area of law, that's one of the more common objections. What do you think is the date of your separation? Okay, well, that's a legal is that your separate property? Legal contention. So those are very common objections in a family law case.
Right. Dan, did you have something?
Yeah, no, I just to give example, same as Brian said, like, did you, I don't do contract law, but I imagine, did you breach the contract is a legal contention. Right. Do you think you were negligent? I think that is a legal contention, but yes. I think you can ask, were you at fault for the crash? I think that's fair game.
I might change it to, do you feel like you did anything wrong? Just to make sure you stay away from words like fault and negligence and liability, because those get closer to legal contentions. But you're right, it becomes a little bit of a gray area depending on how the question is posed.
Yeah.
Tony, I just wanted to comment real quickly on that County of Los Angeles versus Superior Court
Sure.
case. That comes up a lot in my cases when you've got a subsequent treating doctor, and I think it also comes up in auto accidents cases. When you're taking a deposition of a subsequent treater, kind of a third-party recipient witness deposition, and the noticing attorney wants to try and make that subsequent treater into an expert witness on the case. And I'm the one who's usually the one defending the subsequent treater. And my position usually is that they can't give expert witness opinions. The deponent can't give expert witness opinions as to their opinion as they sit here today. They can only give their opinion of what their opinion was at the time they treated this plaintiff back 5 or 10 years ago, if they even remember. So it's important to kind of, that's a big objection that comes up in my cases, that you can't use a subsequent treater as an expert. And I'm sure Dan might have something, different on that. And there's probably ways around that. And a lot of people probably let that go, but I try not to let the subsequent treating doctors be used as expert witnesses.
Yeah,
I know we're running.
I was about to say the same thing, Brian, that we're really at an hour mark. And I know that Brian?
So I would say as for my closing remarks to people as to especially if you're new, be calm in a deposition. Best thing you can do is be prepared for your deposition. Think through the questions, think through the things you need to prove. I would say if you're a new attorney, exude confidence. Even if you're not, even if you're scared, don't worry, because your client wants you to be strong and think you know what you're doing, even if you don't. Fake it till you make it. Pretend you're good. Act like you know what you're doing, even if you don't know what you're doing, and you're probably going to be fine. It's not the end of the world. You can probably rehabilitate or deal with it later. It's not the end of the world. Try your best. Don't overthink it. You'll be fine. You'll learn. Even if you're doing it 30 years, you're still learning every time.
Go ahead, Brian, Dan, and Rachel. Then I'll do the final closing. Go ahead.
Yeah, look, I mean, nothing better prepares you for trial on how to cross a witness than taking lots of depositions. I think, obviously you don't want to use a cross-examination at trial as a deposition format because it's going to bore the hell out of the jury. But, doing a lot of expert depos, doing as many depos as you can really helps you fine tune your skills at trial on how to ask questions the right way, how to use the right wording, how to be concise, how to not let people off the hook. And using depos is trial. So many cases settle when you take a killer depo and really destroy their expert or one of their witnesses. But just always think that this could be played for a jury one day. So think about that when you're defending a depo and how your client's acting and sounding and whether you're going to pull them out mid-question before they give an answer, because that could be shown to a jury at trial. So it's just always think all this could be in trial one day, because that really is what it's for.
Good advice. Rachel.
I agree completely with Brian and Daniel. I'll just add that preparation, like everything else in litigation, is really key. Don't go showing up 20 minutes before to prepare your witness and just tell them to tell the truth. Really fine tune it and get into the details and spend the time on the preparation. Also, civility is key. Keeping kind of the temperature and just being civil with your opposing counsel, meeting and conferring as much as you can. And if you need to take a break during the deposition and call somebody who's got more experience, take a break, step out, ask a question. Hey, is this an appropriate question? When I started out, I did that all the time. And don't be scared to step out and ask questions and enjoy the process.
Sorry, Tony. I just wanted the civility is so important. And that's not to say we're not going to fight. Like, you're going to fight in depots. It's okay. It's part of what we do. I have gotten in huge arguments in depots with some of my closest friends that I'm having a beer with after the depot. So it doesn't mean, but don't make it personal. I see too much, and as a young attorney, I saw it, still see it. It's just don't make it personal. We all have families. We all have tough lives. We're all under a lot of pressure. Fight for the right things. Fight for your client. Advocate for your client, but don't personally attack opposing counsel. They're working just as hard as you are. And when you take the personal side out of it, and you really just you get a little heated about the object. Okay, that's fine. But I think take the personality out of it, and it really will take the stress down for all of us, frankly.
And that may also be including giving the documents you've been asked to produce at the deposition ahead of time, not just that day, especially during the time of Zoom, because it's harder to get that across. And that may be important, or even the exhibits. When are you exchanging those exhibits? Are you going to give up all your exhibits before the deposition, or are you going to exchange them after the deposition is completed? Those are things you might want to talk to your opposing counsel, because it's tit for tat. Whatever you're going to do, they're going to do the same thing. So work it out.
And so I would say in closing that, first of all, this topic is a topic we actually have talked about doing at least one or two more in the series. We haven't even talked about expert depositions. Those are really important and very specific. So we could go on all day, and obviously we don't have all day, so we have to stop it at some point. And so here's where we're going to stop it. But I would just say depositions granularly are important. Get the questions that you need to get answered. If you need to object on certain issues that you want to make sure don't get into trial, make those objections. And then there's a broader view of a deposition. See how the person answers those questions. See whether they would be a good witness at trial. Do they really have knowledge of what's going on, or are they just a bad witness who would not be able to connect with a jury? These are all things that you also use your depositions to learn. And so there's a lot of information. It can't all be done in one presentation, unfortunately. But I thank everybody. Thank you so much for.
Sorry, Tony. There's some really good questions in the chat or the Q&A that we're not going to have time to get to, but I know everyone on here was more than willing to you email any of us,
Yes.
call any of us. We're all happy to help. These are wonderful people I've gotten to know prepping for this. Really great attorneys who are just good people who are always going to help, and I'm happy to as well.
Thank you.
Absolutely.
So thank you everyone for attending this presentation. We really appreciate it, and we'll likely do more like this. Thank you so much.
Thank you.
Everyone.
Thank you, everybody.
Take care.